So welcome to the last day of the Before I Die Albuquerque Festival. I'm Gail Rubin, the doyen of death. And by the way, I also teach Pilates here at the YMCA. Monday, Wednesday, Friday, 6:15 in the morning if you're an early riser. But the rest of the time when I'm not teaching Pilates here at the Y, I am a death educator. That's death, not deaf. And I use humor and funny films and outside-the-box activities like this Before I Die Albuquerque Festival to get us thinking about, talking about, and doing something about our 100% mortality rate. Yes, we are all going to die, but yet less than 30% of us plan ahead for that inevitability. So what does that mean? That leaves 70% of our loved ones scrambling to pull information together and make expensive decisions under duress of grief, and it doesn't have to be that way. Before we get going with our panel discussion of what you need to know before you go, financial and legal issues, I want to give a big shout out to all of our sponsors for the Before I Die Festival, which includes French Funerals and Cremations, and we have somebody here from French. We have the Morris Hall Estate Planning Law Firm, Jim Plitz. We have the Neptune Society and a representative from there. And by the way, we are doing a drawing during the festival for a free cremation from the Neptune Society. If you'd like to participate, there are drawing slips on the far table over there. And I will also do drawings for a gift bag from the festival and a book. So for right here today. So you want to get in on that. Also, Retirement Extender, which is Steve Margulin. The Express Legal Solutions and Lasting Legacy, Tracy Ahr. My final checklist, Life is Short, Zia Trust, are also supporting us, and 1-800-AUTOPSY came in at the last minute. We had a guy give a talk about autopsies. That was a really interesting talk. So let us get down to business, talking about what you need to know before you go. I'd like to ask each of our panelists to just briefly introduce yourself and talk a little bit about your company.
Sure. Good afternoon, everybody. My name is Jim Plitz. I'm one of the few attorneys at Morris Hall. Our law firm concentrates our practice solely in estate planning. We want to make your loved ones have a better experience in one of the more difficult times of their lives. Unfortunately, in your life, you probably won't be as aware. Exactly. Part of me is to part of the reason I got into estate planning is because I get to help wonderful people like yourselves, and I've been doing this for the past 6 years, only doing estate planning, and so far it's worked out pretty well. I get to meet with so many wonderful people, and ultimately I get to help them as well. So thank you guys for coming out today.
Thank you, Jim. I'm Steve Margulin. I'm a CPA and certified financial planner, and probably the largest Dodger fan in the room. So I learned a long time ago that if I watch the investment markets, they go down. So I manage a lot of portfolios, and I never learned the difference between short-term phenomenon and long-term phenomenon in investments. So I spend energy where I can make a difference, cheering for the Dodgers and the Lobos. And so I have a firm. I'm the lead advisor of a firm in Albuquerque. We have 8 employees, and we integrate investment and tax and financial planning procedures together, working for the same client. So I hope that you learn a lot from this presentation. I'm very lucky to be on this wonderful panel.
Hello, I'm Tracy Ahr, and I've been a tax and estate planning lawyer for 26 years. That's amazing because I had to start before birth. But I'm not here today in that capacity. I'm here today with a company that I own with a CPA and a physician. and it's called Lasting Legacy. And what this company focuses on is helping people that don't have any other people in their life that might need to serve in the role as a personal representative or a trustee for their trust. But we are segueing into another business where we're helping people age in place. And so we're getting a certified aging in place specialist to help people with the remodel that needs to be done if they want to stay in their home. And we're just basically trying to get people to be allowed to stay in their home as long as they can, and if possible, die in their home if that's their wishes. So that's what I'm here for today.
Very good. All right, well, we will invite your questions if you'd like to ask questions of the panel, but I'm going to start out with a question about when should we start planning financially, legally, and just in our homes even for end-of-life issues, but also, just planning in general. Should young people be jumping in and doing a will?
So when should you start planning? So who here knows when they're going to die? We don't, right? And so when should you start planning? Today, or better yet, yesterday, but we can't do that. So today, you have to start planning today. Everyone's plan is going to be different. I always say whether you're 18 or 118, you need something. You need at least a power of attorney. You need at least a healthcare power of attorney. People who could make decisions for you if you're unable to. So everyone's plan is going to be different. Whether you're Bill Gates, you're going to have a little more complicated plan, probably need a little more than just a power of attorney. Or you could be the guy on the street corner, panhandling. I think he still needs a power of attorney because if he gets sick, someone needs to make decisions for him. So everyone needs a plan, and since we don't know when we need to utilize it, it should be today.
Well, you go.
Okay. Planning is fun.
It is?
So it's just recently I had a birthday, and I didn't get a birthday card from my favorite granddaughter. She's out of the will. So every year I can put her in or put her out depending upon my mood. So it's planning also is important around the 3 Ds: divorce, disability, and death. And I have a lot of clients that they love their son, but they don't care much about the Wicked Witch of the West who they married. So you have to do the planning so that what you do with your life and your money actually gets actualized.
Well, and again, our focus isn't so much on dealing with the financial aspects of, your nest egg. What we focus on is starting early if you want to stay in your home and age there. There's things that have to be taken care of if you want to do that. Modifying your home is probably the biggest one. One of the other things that we found is with the people that we work with is we'll go into someone's home and find out there's a lot of deferred maintenance, and the maintenance has been deferred because they don't know who to call, so they don't call anyone. So one of the services that we offer is we have someone that's knowledgeable in interviewing and seeing the credentials of contractors that do work in the home, and we just try to kind of act as a clearinghouse for people as well to get things modified so that they can stay at home and kind of prepare their life for living. So,
You have a question. What's your question? Is the power of attorney responsible for what? For their bills, for paying bills, when somebody is still alive. There's a change. Jim, you get to address that one.
Two kinds of powers of attorney. attorney, right?
So, powers of attorney are effective upon life. So if, depending on how you set it up, you could set it up to be an immediate power of attorney so people could write bills using your money right now, or you could have it as a springing power of attorney. So if you became incapacitated, usually it's two doctors or a court saying that you don't have the ability to handle your financial affairs, then the power springs into action. However, when you pass away, the powers also pass away. Now we're transitioning into a death power. So depending on how you planned your estate, whether you had a will, then the power is going to be under a personal representative, which is New Mexico's term for executor. Or if you plan with a trust, then the power is vested or given to that trustee.
Answer your question? Okay, good.
So the answer is no.
I'm a lawyer, so a lot of words.
So when you die and you have debts, they could, and an attorney can answer this better than I can, they could be community property debts that is owed by your spouse, but if you're the personal representative or you're a beneficiary, they're not your debts, and you don't have to pay for them.
So it depends. Did you want to add anything?
Well, I'm just going to put on my lawyer hat here for a minute. What I have had happen in my office probably 20 times is someone will come in after someone has died and then tell me that that day they had used their power of attorney to do something at the bank. So I think there's a real misunderstanding that the power of attorney isn't usable after the principal has died. So that would be something that I think would be important to pass on to your friends too, because I know that my clients come in and they're not meaning to commit fraud, but that's what they've done 5 minutes before they walked in. So that's an important thing to know, I think.
So are you saying community property goes away when you die?
Repeat the question.
So does community property go away when you die?
So you're no longer responsible for your spouse's debts?
No,
Repeat that.
Are you responsible for your community partner's death, spouse's debts upon death? Yes, you would be. If it's all community property, you're responsible. You benefited, the surviving spouse benefited from that debt, from that creditor, or whatever it was, so you're responsible for paying it. It gets a little different if you have separate property, which you're allowed to have, even though we're a community property state. But in general, no, the debts go away, to Steve's point, but it only goes to zero. Debts aren't inherited by the beneficiaries. So it could wipe out an estate, but if you had $100,000 in debt and $50,000 in assets, your beneficiaries aren't inheriting $50,000 in debt.
Here's a question. I've written a book called Kicking the Bucket List, 100 Downsizing and Organizing Things to Do Before You Die. And one of the items on that bucket list is to choose somebody to be your executor or your personal representative, the person who is going to carry out your will or your trust. And to illustrate this concept, I have a picture of a little kid sitting in a big chair behind a big desk, to say that you need to be very careful about who you pick to carry out your wishes after you're gone. So what do you look for in an executor, a personal representative? Tracy, do you want to start with that?
Well, I would start with someone that you trust. One of the things that happens that I think is funny in connection with a power of attorney, for example, somebody will come in and do a power of attorney, and they actually need to appoint someone to act for them now. And they'll say, well, I don't want to have my son act for me as my agent under a power of attorney now, but they have them act in case they're incapacitated. And I'm like, well, if you don't trust them to act for you now, I would think you would not trust them even more to act for you if you're incapacitated. And I think some of the same issues come up when you're trying to decide who do you want to pick as a personal representative or an executor for your estate. One of the things that also comes up is I'll have people that have more than one child that they want to act as co-executors or representatives, and I'll say, well, do they get along? No. No, they hate each other. I'm like, well, why do you want to do that? Well, they'll get mad at me if I just choose one or the other. And I said, well, what's going to happen if you don't? They're going to get mad at you, but they're going to take it out on each other because you didn't address it ahead of time. So.
One of the other things to consider is the age of your personal representative. I mean, if they're your age and you're old and decrepit, what are they? So in looking at a personal representative, just like when we're looking at new friends to bring into our peer group, look for people that potentially could be a generation younger. As we age, our friends are aging, and as we're alive making decisions, it's easy for them to rationalize really stupid things because it sounds okay to them. So you want to bring into your circle of friends younger people, and you want to look at a younger person to be your personal representative.
Yeah, and when you're choosing, when we're having a conversation, figuring out who you want and who you trust, we'll have backups. Life is unpredictable. So the younger person you chose first still might get hit by the Mack truck, and now who's going to step in? We don't want to, though Steve sounds like he would be a great client because he's making changes to his will every year. We don't really want to do that. We want to have some consistency year over year. So if we have some backups, that's great. Corporate trustees or professional services are a great source because they know what they're doing. It takes the family dynamic out of an already difficult time. So having a professional do it, yes, it does cost money, but I think that's money well spent. So it's not just if you have no one, it's sometimes when you have 4 kids, it's still worth having a professional do it because you know it's done right, all the I's are dotted, all the T's are crossed, and the relationship between the family members stays intact.
Plus, and this could be a trust company or a trust division of a bank, correct?
Correct.
Yeah. And could you tell us how those corporate entities would charge an estate for administering the estate?
Sure. So it's about a relationship. So when I see a document that has, Bank of the West or Wells Fargo in it, my first question is, oh, so you bank with them? And if they say no, then is why do you have them as your successor trustee? Because even though the particular trust officer may or may not be there when the time comes, you get a sense of that relationship. You've been with Wells Fargo for 20 years, so you know the kind of business they run. As to cost, it's usually a percentage of the estate value. A lot of the bigger banks will have minimums, so they won't touch anything under a $500,000 estate or $1 million estate. But there are roles for smaller, whether it's a CPA, attorney, fiduciary services that have to fill in the smaller gaps. You could expect to pay anywhere from 1% to 5%, though 5% is pretty rare. A lot of them are tiered, so the more money you have, the less fees you pay because they've covered their base cost. Do you do hourly?
In our firm, what we found is a lot of our clients are very small. They have very small estates. A bank doesn't want to see them. A trust company doesn't want to see them. And they don't have that much that needs to be done. If we're acting as someone's agent under power of attorney and we're paying bills and things like that for them, we do it by the hour because it's just not fair to charge by a percentage, at least for the clients that we're interested in. And a lot of the clients that we have honestly because they don't have anyone else. And they've gotten over the hurdle and decided that they probably needed to do an estate plan, and they got right in the middle of the estate plan and stopped because they had no one that they could name. Now, again, these are very small estates, so actually administering somebody's estate in that instance is pretty quick usually. So, but what I found is unless you have quite a chunk, although they probably wouldn't turn your business down, I think it would not be a very good use of your funds to go to a lot of big banks. Yeah.
Could you just give us a ballpark figure of what you're talking about, the fees? You know, 1%, 5%, or in your case, you charge by the hour. Could you kind of give us a ballpark figure of what that would be?
The question is, what is a ballpark figure on those kind of fees?
Well, it really does depend on what we're going to do. And I'll give you an example. If we're going to have somebody somebody that is qualified to actually do this, spend time and evaluate somebody's residence or meet with a contractor, we might bill that out at $85 an hour. But if we're doing something very ministerial, like just running through and paying routine monthly bills for someone, that might be billed out at $25 an hour. So it really is contingent upon what are you having done and who's doing it. So that's about as good as I can give you as far as an answer goes, because you would just be amazed at all the different things that people need done that.
Yeah, thank you.
Yeah.
Yeah, Gail, your list has 150 items on it for a personal representative, doesn't it? That's a lot of stuff.
Oh, from the bucket list book?
No,
What?
don't you have a list of what an executor should do or something?
Yeah,
like
the executor, no, it's just 50. It's not 150. But it's still involved, very involved. You have a question?
You have everything transfer on death. Do you still need a will?
If you have everything listed as transfer on death, do you still need a will?
Yes.
Says the lawyer.
So
Why?
transfers on death are good. They're triggered on death.
What would be included in the transfer on death?
So a transfer on death would be a beneficiary designation on just about anything. New Mexico actually has a transfer on death deed as well, so real property also can be a transfer on death. We mostly see it on accounts, whether it's a bank account, brokerage account. Your IRAs have a beneficiary designation, so that's not technically transfer on death, but it is. Life insurance beneficiary designation. But you still want a will anyway, because what happens if the beneficiary you designated on that transfer on death dies?
Before you do.
Second person, we don't know which one that's going to be.
Right, and so the will or trust is your backup. So at least it goes to somebody or a charity or something that you would still want if that first person's not there. So it's your catch-all ultimately. So transfer on death does its job when everything lines up perfectly. But again, it's life, so we want to be prepared for the inevitable.
What's the starting cost for a will?
Repeat the question.
What's the starting cost for a will? So we do will packages because the powers of attorney and the healthcare powers of attorney are important. So we don't want those to go for naught. For a single person, we're probably around $1,750. Married couple, probably around $2,500. Since there's two of everything, then.
If you have like your account set up and you have like the 3 sons where any of them can go ahead and get it. Now, if one of them gets a divorce, is that part of their, can the ex-wife come in and get any of that?
Okay, so your question is regarding 3 sons and there's an ex-wife. Are we talking a Wicked Witch of the West kind of thing? If they get divorced, how does that affect their inheritance?
Can
Can the ex-wife get a cut?
Right.
That's where trusts come in, yes?
So it depends. How you plan. So most of the plans we see, the answer would be probably yes. So we're a community property state, so the presumption is everything is 50-50. So a divorce is going to get split 50-50. Now, inheritances can be held as separate property, so there's a little carve out for that. But when you receive an inheritance, let's say I received $10,000 as an inheritance, am I going to go open up a new bank account and put that money in and keep it completely separate? Probably not. I'm probably going to just put it in my joint bank account with my wife. So when she comes to her senses and finally leaves me, she's going to get $5,000 of that inheritance as well as $5,000 or half of everything I own. When you plan with a trust, you can bake in some of that asset protection features. So there's an ability to keep an inheritance protected from divorce or from a lawsuit or from a bankruptcy. So whether you have $50,000 to leave or $50 million to leave, if you're going through that divorce or if you're going through that bankruptcy, that $50,000 is going to be useful on the other side. Without proper planning, that inheritance, the money that you guys accumulated could go to son or daughters or your loved ones' creditors.
Well, again, I'm going to put my estate planning hat on. One of the most favorite meetings that I have with my clients, and I'm being sarcastic, is when somebody comes in and one of the spouses has inherited a great deal from their parents. And it's the conversation where I have to tell that couple that that money that that spouse just inherited is their separate property. So it's up to them what they want to do about that. If they want to transmute that property into community property and put it in a joint bank account or have an agreement where it changes the character. But then it's the conversation in front of my face where they are both realizing that, and the spouse that is not inheriting the property certainly believes that the spouse that is wants it to be community property. And, begins a conversation with me as if that is exactly right. It's not, but, as a lawyer, I'm ethically bound to be truthful, but, I think it's good to know that if you inherit something from your family, it's not community property in our state, so.
But you better say so when you get it.
Well, yeah, but a lot of times you don't know what to say until you get in front of your lawyer and you make them uncomfortable, so.
And we have a question over there.
Yes, my father's deceased and my mother is aging rapidly. I have 2 other sisters. As far as I know, one is the executor, solely. I'm pretty sure it's going to be divvied, equally among us girls. But when the time, and I'm just now thinking about it, so when the time comes, do I get my own lawyer? And is there anything that I should ask my mom to do in preparation?
Okay, she's outlined her family situation and she's wondering if she needs to get her own lawyer regarding the inheritance, yes?
Yes.
Okay.
So you also asked, is there anything that your mom could do? So planning does come from mom's level. So if mom wants to disinherit all 3 of you or leave everything to one of you, that's her prerogative. So the plan has to come from her. So I do encourage that conversation to happen. So whether she has a plan or not already, whether it's a will, a trust, all of the above, none of the above, to sit down with an attorney to make sure the plan does what she thinks it does. I encourage our clients to come back every 3 years to have that review because life changes, laws change, and we think, most of the time I have that conversation, the client thinks that this is what it does, and they're usually surprised that it does something a little differently than they originally thought. So the review is education, and it makes sure that when the time actually comes, it actually does what you think. Now, your other question is, should a beneficiary get an attorney? Attorneys cause problems. So, if everyone gets along, then no. But you want your rights protected. You know, whether it's a simple will or a simple trust, there's going to be language in it that a layperson isn't going to just understand at a click of the finger. So having the advice of an attorney to interpret what should be happening, as well as the New Mexico Probate Code or the New Mexico Trust Code, to make sure that the trustee or personal representative is following all the appropriate steps and reporting requirements throughout the process. So in that sense, yes. But, you know, when ideally, no, because everyone gets along and kumbaya. But
All right, thank you.
Do you want anything?
The other thing to consider is we don't know what we don't know, and we think we know something. For example, as our minds change, we think that our will changes to what we think it's supposed to say. And I read wills. As a financial advisor, I read wills, I read it back to the clients and say, this is what it says. Is this what you want it to do? I can't believe it said that. For example, I met with a couple who had 2 sons. And the 2 sons were going to split everything 50-50. But the 2 sons are now married. And what if one of the sons had passed away? Do they want the son's inheritance to go to the surviving son, or do they want that money to go to their daughter-in-law, who they love like a daughter? And the will was written before the 2 sons were married, back in 1840. So we have to reread wills, because they don't change as our mind changes, and what they say may not be what we think they should say.
In my practice, and some lawyers don't agree with this, but I don't think surprises are really good. So I have situations where a client will come in and they're doing their will, and they have helped one child considerably. They've put them through school, they've bought them a house, they've done a lot of things for them. They haven't done those things for their other children. So when they're writing their will, they're not leaving that child an equal share. And I said, well, did you tell them that? Well, no. And I said, well, here's the deal. When you die, they're going to be mad that you didn't do that, didn't leave them an equal share, because they're going to forget that you've done that. And you're dead, and it's not good to be mad at you for so long when they've got 2 people there that are sitting right there that are living. And they end up getting mad at their siblings that had nothing to do with it. And so some lawyers take the position, well, you know, it's their estate plan. They don't need to share anything with respect to their estate plan with their kids. Well, I kind of disagree, because that doesn't work out very well. And I don't know any situation in my practice where there has been a dispute with respect to property after somebody's died, that those relationships heal. They don't. They don't. It just goes on and on and on. And the person that they should be mad at is long gone. So I'm more for a full disclosure, especially if you're not going to treat someone equally for a legitimate reason.
I'm just going to say, when we had ours done, when we got the draft copy back, we had 2 children. The 4 of us all sat down and had them read through it and talk about it, and said, if there's anything you don't agree with, this is the time to bring it up before we finalize it. And you know, it was interesting because, number one, I figured they would be our power of attorney for both medical and financial and the trust. It was real obvious that they were very uncomfortable with the medical one. So we went to a niece who is a physician that is now our medical power of attorney. And she said, you know, we talked about that too, that she would certainly involve them in the conversation, but ultimately she would have that last say. And, you know, so it was very different on that aspect than we ever thought it would be, you know.
So do you have a question?
I guess I don't.
All right. So she shared her story about reviewing the paperwork with her kids and discovering the kids are not comfortable with the idea of being the medical power of
What
attorney.
they were saying though,
Yeah.
that, you know, you can't make assumptions, and we actually had with somebody in his family that just split the family at death because of some monetary things. And it's like, I would never want my kids to do that to each other. So it was like, you have to be involved in this now.
Yeah. That's a great point to actually bring us to a close, because I know we have the costume contest that needs to be conducted. So would you all like to make some closing statements about what you'd like our people to take away? One more question?
Say something about probate.
Probate. Say something about probate in New Mexico.
Everything has to go to probate.
So probate in New Mexico isn't as bad as some other states, though I don't want to go to court. As an attorney, I don't want to go to court because courts have judges, and though they're 99% awesome, they also are overworked and overburdened, and sometimes their decisions don't logically fit with what your view is. So in my mind, estate planning is a lot risk mitigation. I was a project manager in a former life, so an issue is a problem that you're confronted with today that you have to deal with. A risk is something that may or may not materialize in the future. Estate planning is dealing in the future in most cases, so we're dealing with risks. Things that may or may not happen, but if we properly plan, we could control if they do materialize. So probate can be okay, can be a relatively straightforward process. It was last year, New Mexico enacted a statute that says you cannot informally close a probate until 6 months after it's open. So we have a little bit of a time issue that goes on. The average cost here in New Mexico is 5% of the estate value. And that's an average, so that it could be cheaper, it could be more expensive, just as an average. So there are some risks associated with probate, but...
Do you have to do probate if you've got everything already?
Do you have to do probate? Probate, real simply, is a process of giving power to a person to move assets from a deceased person to living people. So if there's no assets to move, you don't have to do probate. There's families here in New Mexico that I have to deal with, unfortunately, that great-great-great-great-great-grandpa owned this land and it's been family land year after year. Did they have to do probate? No. But now this generation's trying to sell it? Yes. Now, because there's no power, how does the current owner, in air quotes, own it? So we have to get power over that property at some point.
I think some people have a misunderstanding about probate and what it is, because I'll have people come in and say, well, I have a will, so I'm not going to have probate. And I'm like, no, not necessarily, because it does depend on how your assets are held and whether there's a means to pass those assets at death. If you have a situation where you hold a residence and you're the only person on the deed, there's no means to pass that property to your heirs or beneficiaries unless there's a probate. So many people think that, oh, good, I'm going to get a will so I don't have to have a probate. I'm always so sad to tell them, well, maybe not. So
The other thing you want to consider is your personal assets. So my wife has a jewelry store. It's called her Neck. Who's going to get all those necklaces that we've bought for the last umpteen years? And so something to consider. There's a lot of methods on having kids go through the house, like artwork. You give them a Post-it note. They go in the house with their Post-it note and put a Post-it note on what they want. But there's a lot of planning, and I don't know if non-titled assets such as jewelry and artwork is probated.
You should address that.
Technically, it's about the value. So if it's above $50,000, technically it should go through probate. most estate planning documents, trust will have a mechanism to be able to give and keep a written list of who gets what. Not a fan of the Post-it notes because they fall off and they could be moved. Lists are much better. So keep a list. And it's not really about the jewelry store that's worth $50,000. It's really more about the sentimental aspects. Those pieces that might have a memory that your son or daughter really is clinging to, and you might not even know it. It goes to the communication aspect. Talk to them, because their memories are going to be different than yours. Their experiences in that house are going to be different than yours. And when you're fighting over the jewelry and they're worth $50,000, you're not going to pay an attorney more than $48,000, because at some point it's not worth it anymore. But that sentimental doesn't have a cap. That fight could keep on going and going and going, because it has that meaning, even if it's only worth $1,000.
But can that just be put in a letter, or do you have to?
Can that be put in the letter? It should go through, it should be in a will or a trust. Again, technically if it's worth $50,000, it should go through the probate. There's no real monitoring of that. Possession is 9/10 of the law.
Yeah. And we have one more question. If a house is in a will, does it have to be probated?
If it's already in
Property.
the will that it's going to this particular person.
In the will that it's going to a particular person.
Yes.
Yes.
Wills go through probate. Wills are instructions to judges that are effective upon death. So up until you're dead, they're not effective. And then when you're dead, you're not there to tell the judge, this is really what I meant. So the judge has to prove that that's really what you meant, and it has to go through the probate process in order to give your executor, your personal representative, the power to effectuate your intent to give that house to whoever you've laid it out to. Is it different in a trust? Yes, because then the trust legally owns the asset. You don't own it anymore, so we don't have probate with a trust.
Wonderful panel discussion. Can we have a round of applause for our panelists today? Thank you so much.